The case of Taylor and Caldwell has to do with the removal of a condition of performance, rendering the performance of contractual obligations of either party impossible. It has been credited for spearheading the development of the doctrine of frustration in contract law. Here, a music hall was hired for 4 nights of concert entertainment. However, through no fault of the parties, the music hall burned down even before the first night. Was the hirer obliged to somehow procure a music hall for the hiree, and is the hiree obliged to pay the hirer notwithstanding what had happened? The court held that the answer to this is no. Both parties were discharged from their respective contractual duties. Justice Blackburn gave the leading judgment. He stated that it was obvious that neither the hirer nor the hiree had any express stipulations of what should happen if the music hall burnt down at the time the contract was made. He states, there seems no doubt that where there is a positive contract to do a thing, the contractor must perform it or pay damages for not doing it, although in consequence of unforeseen accidents, the performance of his contract has become unexpectedly burdensome or even impossible. But, he says, this rule is only applicable when the contract is positive and absolute, and not subject to any condition either express or implied. Blackburn J. goes on to consider several cases where it seems that a party was excused for not performing on the grounds that there was an implied condition in the contract, a certain subject matter, a person or a thing, had to continue to exist in order for performance to be possible. And then before what would have been a breach, the thing ceased to exist. For example, he raises the examples of promises to marry or promises to serve someone, and the contractual party dies unexpectedly before they were supposed to get married or they were supposed to serve. In these circumstances, the condition for performance had been removed prior to fulfillment. Similarly, there are also cases involving the sale of property where before the goods were delivered to the buyer, through no fault of the seller, the goods had perished in the meantime. Again, in those circumstances, the parties would be excused from performance because performance would have been rendered impossible. Coming back to this case, Blackburn J. held that the principle seems that in contracts in which the performance depends on the continued existence of a given person or thing, a condition is implied that the impossibility of performance arising from the perishing of the person or thing shall excuse the performance. In the present case, looking at the whole contract, we find that the parties contracted on the basis of the continued existence of the music hall at the time when the concerts were to be given. We think, therefore, that the music hall having ceased to exist without fault of either party, both parties are excused. The plaintiffs, i.e. the claimants, are excused from taking the gardens and paying the money, whilst the defendants were excused from performing their promise to give the use of the hall and other things.